So you've started a corporation. Congratulations! Now it's time to figure out exactly how to dial in on those details of what drives a healthy board of directors for your startup. So to keep it simple, it comes down to two things: the board's functions and the board's responsibilities. So if these two components are crystal clear to all board members and the owners alike, then you're setting yourself up for success. I'm Andy Contiguglia. I'm the owner and the founder of the Contiguglia Law Firm here in Denver, Colorado. We deliver ambitious, creative legal and business solutions for the game-changing company so you can feel confident that your business is protected. All right, so let's sit down for some coffee, bagels, and legal, and let's talk about the functions and responsibilities of your board of directors. So at a high level, the board of directors is there to advise and manage the organization. So think of it as the steering committee to the greater company. Each particular board member can be an expert in a specific field of business, anything from finance to operations, and they all work collectively to make sure that the decisions are made in the best interests of the company. When elected to the board, the directors adopts a handful of responsibilities that will set the framework for how the board operates for the life of the company. This is through the bylaws. They keep their hand on who runs the organization by electing officers to lead the day-to-day operations. They also have the power to make major decisions, things like merging with another company, acquiring a competitor, or even selling or shutting down the organization. All of these fall onto the shoulders of the board of directors. So, at its core, the directors focus on the big picture and they oversee the prosperity of the corporation. They are also ones to keep the interests of the shareholders and the relevant stakeholders in mind as they direct the company's affairs. What is their goal? To keep things moving in the right direction. In order to do this, directors must keep a strong pulse on the company and review relevant reports that mirror the company's health prior to each board meeting. Now, it's important for the board members to understand the weight of their role. Every director on the board has a fiduciary responsibility to the corporation and to the stakeholders, which means all direction and advice given is in the best interest of the company's growth and its well-being. Specifically, these fiduciary responsibilities can be broken down into 1, the duty of care, and 2, the duty of loyalty. Now, I've put together a PDF on the duties and responsibilities of the board of directors. It's linked below in the comments. It's free, so don't hesitate to download your copy. So think of it this way. At a high level, the duty of care says that each director is to be fully informed of all material information that is available to them when they make a decision on behalf of the corporation. In other words, they will take the time to understand the matters at hand and make intentional and purposeful decisions under every circumstance. Now, they can't just walk into a meeting and raise their hand and say, "Hey, I'm going to make a vote," when they haven't really been thoroughly briefed on the subjects. In addition to doing their due diligence, each director is also responsible for keeping their personal interests separate and apart from the interests of the company. This duty of loyalty puts the director in a position that requires him or her to act in good faith for the benefit of the company and its shareholders rather than to his or her own personal interests. Now, we've seen instances here where board members used inside information to make profitable investments for themselves without first obtaining authorization from the board of directors. That person was obligated to repay the profits earned to the company for which he acted when he was a board member. We've also seen situations where a director of one of the corporations was working for a competitor. That situation also presents its own set of specific legal problems. But the reality is this: when a board member puts his or her own personal interests above the interests of the company they serve, they can be held personally liable for breaches of their fiduciary duties. With that said, it's critical that all board members understand their role and commitment upon being elected to the board. It's not necessary that every decision or vote of a board member drives profits, but there does need to be a rational business purpose behind every move they make in connection with the company. The good news for the board of directors, generally speaking, is that board members are protected by what's called the business judgment rule. All right, this rule assumes that directors are acting on the golden standards of good faith and in the honest belief that what they are doing is in the best interests of the corporation with a sound understanding of all the information available. Now, this rule stands true for those board members who have good intentions but seem to have made decisions that don't necessarily align with the expectations. Not every decision can be a great one, but as of course, with almost anything, this rule can be refuted with evidence. So for those board members who have sticky fingers, there are other repercussions that come into play. from acting in a conflict of interest to operating in bad faith. These create various responsibilities that need to be acknowledged and respected as a board member in order to keep things running smoothly and also to keep you out of the courtroom. So as you go and you grow, remember to formulate your board of directors and make sure that every member up for election is fully aware of the commitments that he or she will be responsible for making if elected. Be sure to clearly outline their fiduciary responsibilities, including the details behind their duties of loyalty and their duties of care. Even more importantly, help them understand the repercussions and breach and exactly what would entail if that happens. So each of these elements can be clearly outlined with expectations specific to your organization in the initial organization documents as you file and you complete your business and as you open up the doors to your corporation. So if you need a quick brush up on what those documents are, well, make sure to watch my recent video about the 5 documents you need to launch your corporation. All right here. Among those documents is obviously the certificate of corporation, and as I mentioned earlier, the bylaws, which create the foundation for how your corporation will operate. When formulating this, you can include provisions that eliminate or limit the personal liability of directors to the corporation for monetary damages or breach of fiduciary duties. However you decide to go about this, understand that there are layers to the legalities and responsibilities behind your board of directors, and this also requires due diligence on your part to set up the corporate governance at this scale. Again, if you have any specific questions about what needs to be done as it relates to your organization, feel free to reach out to me directly. I'm always happy to be an informal sounding board to you as you dial in on your details, setting up your company, making sure you get off on the right foot. I encourage every one of you to subscribe to this channel to keep yourself informed to the legalities and the strategies behind protecting your business and building your brand. My goal is to share these tips and tricks with you that will help guide you in making sound business decisions, keeping your brand, operations, and overall business protected for years to come. So if this video was helpful to you, give it a thumbs up. Click the subscribe button below and get updates each week as we put out new videos. Again, my name is Andy Contiguglia, and until next time, remember, don't skip the legal. Good luck.